Zimbabwean businesses face enormous pressure: low production, currency instability, and persistent inflation. For many SMEs and family-owned companies, survival itself has become the main objective. This is where formal insolvency options matter. And one of the most important is corporate rescue proceedings. I am Calverwell, and I help SMEs manage restructuring and create the clarity they need to grow with confidence. In this session, we'll walk through the step-by-step process of corporate rescue proceedings. Corporate rescue is about rehabilitation. It's a legal process under the Insolvency Act. The primary goal is to bring the business back to profitability. The secondary goal is to achieve a better return for creditors and stakeholders than immediate liquidation would provide. How does it work? By placing the business under temporary supervision by an independent corporate rescue practitioner and protecting it from creditor action through the general moratorium, supervision, protection, a rescue plan. These are the three pillars which form the foundation of corporate rescue proceedings. There are two ways to commence corporate rescue: voluntarily through a board resolution under Section 122, or compulsorily through a court order under Section 124. In both cases, two requirements must be satisfied. First, the company must be financially distressed. Second, there must be a reasonable prospect of rescuing the company. Financial distress has a specific legal meaning. A company is financially distressed when it appears reasonably unlikely to pay its debts as they fall due within the next 6 months, which is commercial insolvency, or when it appears reasonably likely that the company's liabilities will exceed its assets, that is balance sheet insolvency. Both the future outlook and current insolvency are considered, especially in voluntary corporate rescue. The second requirement is reasonable prospect. Two phrases matter here: rescue, which means either returning the company to profitability or ensuring a better return than liquidation, and reasonable prospect, which means there must be a factual basis. It is not about hope, it is not about speculation, it is about evidence. In compulsory corporate rescue, affected persons may apply to court, which includes shareholders, creditors, employees, or their trade union representatives. Because they often lack detailed financial information, the Act allows the court to also consider failure to pay employee-related obligations or other just and equitable reasons. This ensures genuine distress cases can still be placed under supervision. Beyond directors and affected persons, other stakeholders shape the process. The corporate rescue practitioner, appointed by directors, creditors, the Master of High Court, or directly by the court. The Master of High Court, who manages the process and ensures the practitioner is accountable. The courts, which uphold the legal framework and protect the balance of interests. For voluntary corporate rescue, the board files a resolution with the Master of High Court and the Registrar of Companies. Within 5 business days, affected persons must be notified. A practitioner must be appointed, and within 2 days of appointment, that appointment must be filed with the Master and the Registrar of Companies. Failure to comply with these timelines renders the proceedings null and void. Affected persons may also apply to court to set aside proceedings where due process was not followed, where no reasonable prospect exists, or where the company is not financially distressed. In compulsory proceedings, an affected person applies to the court. They must serve copies to the company, the Master of High Court, and the Registrar of Companies. The court then determines whether supervision and corporate rescue are appropriate. Once appointed, the practitioner assumes full control. The board of directors is dissolved, management powers shift to the practitioner. Their first duty is to investigate the company's affairs, to assess viability, and to decide if rescue is achievable. Within 45 days of appointment, the practitioner must publish a corporate rescue plan. The plan outlines the company's background, financial restructuring proposals, the effect on creditors, shareholders, and employees, and the overall feasibility of success. The plan is presented at a creditors meeting. For adoption, approval requires 75% in value of creditors who vote, with 50% being independent. Once adopted, the plan becomes binding on the company, the creditors, and the shareholders. Corporate rescue is expected to conclude within 3 months, as set out in Section 125, subsection 3. But in practice, timelines depend on circumstances. Termination occurs when the practitioner files notice of substantial implementation, or when the plan is rejected without extension, or the court sets aside the resolution or converts the process to liquidation. Corporate rescue is not a shield for failure. It is a statutory mechanism to rescue companies, to protect jobs, and to preserve shareholder value. And when rescue is not possible, it ensures creditors receive a fairer return than immediate liquidation would provide. If your business is facing financial distress, do not wait until it's too late. Explore corporate rescue proceedings and ensure the future of your company.